all unequally, resulting into discrimination, all unequal treatment based on the criteria laid out under Article 2 and 3 of the Charter. In view of the foregoing, the court finds that the applicant's rights to non-discrimination, his right to equality before the law, and to equal protection of law as guaranteed under Articles 2 and 3 of the Charter were not violated by the respondent state. Reparations. The court notes that since no violation has been established, the issue of reparation does not arise. Consequently, the applicant's prayers for reparation is dismissed. Costs. The court notes that Rule 30 of the rules provides that unless otherwise decided by the court, each party shall bear its own costs. The court finds that there is nothing in the instant case to allow it to decide otherwise. Accordingly, each party shall bear its own costs. Operative part. For these reasons, the court, on jurisdiction, unanimously, 1, dismisses the objections on the jurisdiction of the court, and 2, declares that it has jurisdiction. On admissibility, by a majority of 8, 4, and 1 against, Judge Susan Menge, dissenting, dismisses the objections on the admissibility of the application and declares that the application is admissible. On merits, unanimously finds that the respondent state has not violated Article 2 of the Charter on the right to non-discrimination, finds that the respondent state has not violated Article 3 of the Charter on equality before the law and equal protection of the law, finds that the respondent state has not violated Article 7, subparagraph 1A of the Charter on the right to have one's cause heard by a competent tribunal, and finds that the respondent state has not violated Article 7, subparagraph 1A of the Charter on the right to be tried by an impartial tribunal in respect to the composition of the review bench of the Supreme Court. By a majority of 7, 4, and 2 against, Judges Gerard Nyungeko and Rafa Ben Asho, dissenting, finds that the respondent state has not violated Article 7, subparagraph 1D of the Charter in respect to the remarks made by Justice Dotse in his concurring opinion in the ordinary bench of the Supreme Court. On reparations, by a majority of 7, 4, and 2 against, Judges Gerard Nyungeko and Rafa Ben Asho, dissenting, rejects the reliefs sought by the applicant. On costs, unanimously decides that each party shall bear its own costs. The judgment has been signed by the judges mentioned at the beginning. In accordance with Article 28, 7 of the protocol and Rule 65 of the rules, the dissenting opinions of Justice Gerard Nyungeko, Rafa Ben Ashur, Susan Menge, and individual opinion of Chafika Ben Saula are appended to this judgment. Done at Arusha, this 28th day of June, in the year 2019, in English and French, the English text being authoritative. Thank you, Honorable President.